we were discussing about checks. So you, some of you are, I mean, most of you are bankers. That when we discussing this topic, that you may come across questions. You may have a lot of concerns because you may have faced some situations with regard to the checks, and as a situation that you have faced when you are clearing or collecting checks. Those things that we can discuss then and there, and we can enhance our knowledge by discussing, because you have a practical knowledge, the practical situations that you have faced. So on the other side, that I have theoretical knowledge and with little practical experience also. Okay, we were discussing about the checks. So I think that we discuss up to here, checks in writing, right? Is that correct? We discussed this slide, no, Vidura?
So actually, we did not start the chapter last week.
Sorry?
We did not start the chapter last week, as I remember. We stopped before that, right?
Here?
Yeah.
Right. So, okay, so then we have to start from slide number 7, right? Okay, right. So the check. We are actually studying the law related to checks and some principles, law principles, and also some practices developed by the bankers, which have been accepted by court of law as a law. So therefore, it has been now developed as a law. So those things that you have to remember when it comes to checks. We have a statute, that is Bills of Exchange Ordinance. There is no separate act or enactment or ordinance for the checks. The checks are also governed by a Bills of Exchange Ordinance. There is a separate chapter for the checks in the Bills of Exchange Ordinance. That is the statute applicable to the checks. And apart from that, as I told you, as in other sectors of the banking law, check law also, the law related to checks also have been developed by court of law by adopting the practices of the bankers that they have practiced for a long period, and they have accepted those practices as a law in the banking sector. So therefore, it has been now accepted by courts by several judgments. So now it has become a part of the law. So those things that you have to remember when it comes to the law related to the checks. So one legal requirement or legal principle is that check must be in writing. So this is something that we have to think about, because now we are in a era where we used to do a lot of things in using technology, electronic modes. For example, we have now banking also in this era. So we do a lot of e-bankings. We don't use much paper or wet signatures and all. So this is one thing that we have to I would say there's a barrier when it comes to e-banking, because the law very clearly says the check must be in writing. So when it comes to in writing, the question is whether we can use e-mode. So whether it is electronic check, whether we can use electronic checks. Now that has not developed yet, because the practice and the law established is that the check has to be in writing and there has to be a physical check. So that one day that can be developed to another step, and one day we will have, sometimes one day we will have electronic checks also. For the time being, we have to remember check has to be in writing, and ideally it should be written in ink or typewritten, can written in using a typewriter. So the check, the check, there is a format. When it comes to the checks, we have printed formats, and there are blank places that you have to fill the check. So the idea behind this principle is the check has to be filled by handwriting using ink pen, or by typewriting those spaces. So those are the commonly accepted methods of completing a check. However, there can be a situation where a customer use a pencil. So the question is, if a customer use a pencil, whether the check is invalid. The answer for that question is check is not invalid. In other words, check is valid. Just because the customer has written the check by using a pencil, that we have no reason to reject the payment or reject the collection. So that we have to remember. But the common practice is use an ink pen or typewriter to fill the check. So what happen if a customer has used a pencil? What is the concern? That when we see a check written using a pencil, the concern is the check then easily can be altered. So as you know, when it is written in pencil, that it can be erased very, very smoothly. And for example, we say the amount, a customer write 1,000 rupees. Someone can, the drawer can write 1,000 rupees in words and figures by using a pencil. Someone can erase the word one, and they can put write using a pencil 10. So then it becomes a 10,000. The value of the check becomes 10,000. So then it is an altered check. So we know that if a check is altered, check is not valid. So then if we pay the check, the banker is liable. If you pay an altered check, a wrong payment, if you make a wrong payment, so then you have to return that money to the customer. That is a principle that we are going to discuss later in our lesson. So, so that is the danger, that is a concern that we have. So, however, on the other hand, the check is not invalid. So that means that we have to pay the check. So what are the requirement that we have to follow, or what are the things that we have to see before we collect or paying the check? So check can be accepted if it is written in pencil, but if there is a reason to suspect, this is very important. If there is a reason to suspect, the banker should not pay such check without a confirmation from the drawer. So that is the requirement. If there is a reason to suspect, the banker should get a confirmation from the drawer before we pay the check. Especially this is applied to the paying bank. Now you see, when you get a check written in pencil, that itself is a reason to suspect. That's what I have to say. Because if a customer has used a pencil without using a pen, right? So that itself is a reason to suspect. A prudent banker should get a confirmation before we pay the check, if it is written in pencil, right? So now the question is, if it is presented to a different bank and it comes through the clearing process, how could you identify whether that is written in pencil or not? Because you know that now we use image clearance system where the check is scanned and sent to the clearance, and when you scan the check you can't see whether it is written in pencil or ink. So in a situation like that, what is the situation of the paying bank, and what is the liability of the collecting bank? Anyone can think about that? Anyone, any answer for that? If it is written in pencil, and if it is comes through the clearance process, how do you recognize that the check has been written in pencil, and what is the liability of the bank, collecting bank, and as well as the paying bank? When it comes to check clearance, right? Basically, whether it's written in pencil or written in pen, or whether it's typewritten. So, what are the responsibilities of the each bank, that is collecting bank and the paying bank? Anyone? Any banker? Ranga, what do you think? Is there a responsibility on the collecting bank side, Ranga?
Since it is collected at another bank, I think collecting bank also have a responsibility in verifying the check, I suppose. I'm not sure.
Okay, so what is the responsibility of the collecting bank? Now, for example, we say Sampath Bank is collecting a check of their customer. The check, it is a H&B check, right? So now the customer deposit that check to the Sampath Bank account, and then what is the process? So it will clear through Lanka Clear. The image clearance will be applied. So the physical check will not go to the clearance, only the image will go. So as I told, when you scan the check, you can't see whether it is written in ink or whether it has been altered. So what is the collecting bank's responsibility? The collecting bank's responsibility is, remember, they have to observe any special remarks or any special features of the check. If the check is written in pencil, that is a special thing that they have to observe. And also, they have to observe any alterations or there. If there is any alteration visible to the naked eye, and or if it is written in pencil or something into that effect, the collecting bank has an obligation. The collecting bank has two options. One is that collecting bank can refuse to collect the check, right? That is number one. Or the collecting bank can collect the check and with a remarks. If it is altered, that they have to inform the clearing agencies. Otherwise, that it will not capture once it is scanned, or once it is scanned and send the image. Now, there was a situation where a bank has collected the check. I would say they have collected the check wrongfully, negligence. What has happened? The check was, when it is the physical check, so then there was a dispute. The payment has gone through the clearance, and the drawer disputed the payment. We say HNB, sorry, we get A bank has collected the check and B bank has paid the check. Now, the customer of B bank, that is the current account holder, drawer, dispute the payment of the check. He says, no, I never issued a check for this value. I issued only for 1,000 rupees. Now you have paid 100,000. So he says, now it is altered. So when we check the transaction, it has been cleared through the the payment agency, so clearing agency. So image clearance has occurred. So then when we then the customer file action, and when the check is presented for the codes, the physical check, then it is very clearly observed that it has been altered by using a Tipex. They have put the Tipex on the amount and written on the after Tipex, you applying Tipex, they have altered the check. So it is visible to the naked eye. So the collecting bank has erroneously and negligently collected the check and has sent for the clearance without any notification. So what happened? Then the paying bank anyway had to return the money to their customer, because law is very clear. When the check is altered, the paying bank has no right to debit the customer's account. If it is debited, the bank has to return that money to the customer. So then immediately that bank paid their customer, and sued the other bank. So the responsibility or the liability shifted to the other side, to the collecting bank. So what I have to say here is, sometimes when you are doing your banking businesses, you act as a collecting bank, and also sometimes you act as the paying bank. So if you are collecting your customers' checks, other banks' checks, so then you are a collecting bank, then you have a responsibility. Don't think that it is not our check, the paying bank is somebody else, so therefore there's no responsibility from our side, it is up to the paying bank. It is not the case. So the practical scenario that you have to think about. So if you collect the check, if you have collected the check negligently, without observing any visible defect, so that shows that you are negligent and your collection is wrong. So then the liability can shift to the collecting bank. So therefore, it is very important to observe these alterations or any special feature of a check when you are collecting. So that you have to remember as a collecting bank. And printed check forms. So then the next the principle is, now the banks, all banks, use printed check forms. The question is whether it's a legal requirement. If a bank refuses to honor checks which is not drawn on a printed check forms, the banker should give reasonable notice. That is the principle. So first thing that you have to remember, using of printed check form is not a legal requirement. So this you have to remember. I told you before, there are practices that the bankers used to do, which have been accepted by court of law. So this is one practice that the bankers developed, and later the court accepted as a part of banking law. So initially, you remember, we didn't have printed checks. I'm talking about, we say 150 years before, when they doing banking businesses, when they maintain current accounts, they didn't have printed check forms. So the requirement was, the check has to be written by using an ink, or it can be typewritten. So basically, if a customer, current account holder, if he takes a A4 paper and typewrite a check, so you know what are the features of the check. So all the features, if you typewrite to the check, typewrite on the sheet of paper, and if the customer or the account holder sign that, so that can be considered as a check under the bills of exchange ordinance. So you may remember, check is a unconditional order given by the account holder, the drawer, to the bank to pay amount in certain. So that is a requirement. So if you give that instruction in writing, if a customer, if account holder give that instruction in writing by using an ink pen or by typewriting and signing the document, that can be considered as a check. However, now what is this the situation today? Can we accept those type of checks or written instructions as a check in today's context? Obviously, we know that it is not possible, because it will not accept by the clearing process. So they have given a clear specimen of a check by Lanka Clear. So this is the format that they have given. Unless the bank use this format, that it will not they will not able to clear the check. So you see the length and the width also they given there. So these features must be there. So basically that now 100% all the banks are using printed check forms. Then the situation is, on one side, the bills of exchange ordinance say it is not necessary to use printed forms, and the other side, the developed practice, banking practice is that we are not allowing customers to write any checks other than on the printed check forms. So therefore, the court has developed a principle. It says, if a banker refuses to honor checks which is not drawn on a printed check forms. So basically, we are refusing to accept any check other than checks written on given printed forms. So then what is the responsibility of the bank? The banker should give reasonable notice to the customer. So if we are not accepting any other type of checks formats other than the printed check leaves or printed check forms given to the customer by the bank should give a notice. So then the question is whether we give notice to the customer. So we give notice to the customer at the time he opened the current account. Or sometimes you can see that is printed, those conditions are printed in the checkbook also. So in there we clearly, or sometimes it appears, these conditions appears in the general banking terms and conditions, or in sometimes those are mentioned in the checkbooks also. However, this condition says that the customer should use the printed check forms and he cannot use any other forms of checks, and bank reserve the right to reject such checks if it is not written on bankers given format. So that notice normally we give in that manner. So therefore the bank can refuse the checks written in other forms, and customer cannot claim any damages because the notice is given. So that is about the check in writing. So the first principle, check must be in writing. So any questions from here, if you have? Okay, if you don't have questions, then I'll go to the next one. The next important feature of the check is the signature of the drawer. So when you get a check to your hand, there can be several signatures in the check. The first important signature is the signature of the drawer. So then there can be signatures of the endorsers also. So that is in the back side of the check that you can see there can be signatures who have endorsed the check. So main signature of the check is signature of the drawer. A check has to be signed by the drawer personally or by the authorized signatory. So that is the first principle. To validate the check, the drawer the account holder has to sign the check. So he can sign personally if it is an individual customer, individual current account holder. He himself can sign the check, or he can appoint an agent by a power of attorney, using a power of attorney, to operate his account. That is also possible. However, a check signed by the power of attorney holder is considered as a check signed by the principal, that is the account holder. It is valid as signed by the account holder himself. That is one. If it is a corporate account, or if it is a partnership account, or if it is a account of a society, so then what is the situation? So that can, then the check can be signed by authorized signatory. So those type of customers, companies, partnerships, and societies, they have to appoint an authorized person to sign the checks and to operate the account, and they have to inform the authorized signatory to the bank. So then authorized signatory will deal with the bank with regard to issuing checks. So basically, those are the two methods that a check can be signed: by individually, personally, or by an authorized signatory. Then can be signed in ink, or by using a pencil, or mechanically, or by rubber stamp. I think that we discussed this last week. I'm not sure. So basically, pen, we can use a ink pen. That is the common method of signing, using a ink pen. Also, a customer can use a pencil. As I told you before, he can use a pencil to write the check. So therefore, signing of a check also can be done by using a pencil. Then mechanically sign. Mechanically sign means, you may have observed this. Sometimes you get a check where the signature of the check also printed on the check. For example, dividend checks. When a company is issuing a dividends to the shareholders, we say the company has 100,000 shareholders. So basically, then 100,000 checks will go to the shareholders as dividends. So if authorized signatory has to sign these checks individually and personally, so he will not be able to do this anything else other than signing these checks for the year. So what is the solution for that? So the authorized signatory's signature print on the dividend check at the time they are printing the checks. Those printing of those checks, dividend checks, are very secure process, I would say. It is those are printed with the high security and security, because the signature also print on the check leaf itself. So that is mechanically signed checks. Then a check can be signed by using a rubber stamp also. So example, law firms and audit firms, accounting firms, they use a rubber stamp. So rubber stamp means their signature, they sign in their business name. For example, we say we take a law firm, we say there's a law firm called Paul Ratnayaka Associates. There is another law firm called Sudat Perra Associates, likewise. So they how they sign in their checks, they sign as Paul Ratnayaka Associates and Sudat Perra Associates, likewise. So basically, it is not a name or a mark of an individual person. So anyone in that organization can write the name Sudat Perra Associates or Paul Ratnayaka Associates. Anyone, right? So what they do is they have a rubber stamp where their signature has been cut. So when they are issuing checks, they place this rubber stamp where the place where you have to sign. So that is another method of signing checks by using rubber stamps. So all these are legally acceptable. So that is important. By using a ink or by using pencil or mechanically signed or by using a rubber stamp, if it is signed, those are valid checks. Then another important point there, even though these mechanically and rubber stamp signatures are accepted by court of law, by law, the typewritten signatures are not accepted. Basically, you can't typewrite the signature where you have to sign. So, for example, Kolratnayak Associates can't typewrite their name where the place where they have to sign. They can use a rubber stamp, but they can't use the typewritten signature. That is not allowed under the law. Then the signature can be fiction name or even a trade name. As I told you before, it is not necessary to sign your actual name, right? You can use a different name or even a fiction name, right? And it is not necessary to sign the name. You can have a mark as your signature. Not necessary to sign the name. Then trade names also can be used as a signature. As I told you before, associates, Nimal Pereira Associates, accountants and lawyers, law firms, they use these trade names also. Even other businesses also can use the trade names. A company check can be signed by the agent of the company or authorized officers of the company. So this is another important point that we have to remember when it comes to corporate clients, companies. The company is a legal entity; it's not a natural person. So therefore, the company has to appoint an authorized officer or officers to sign checks, especially when they are appointing authorized signatories. They can pass a resolution and appoint authorized signatories. Most of the time, when they are appointing authorized signatory, they appoint with a limits. So basically, if it is, we can see sometimes they pass a resolution where they gives authority to a person to issue checks up to 50,000, and if it is more than 50,000, between 50,000 and 100,000, two officers have to sign. Likewise, they can restrict the authority of the officers appointed to sign the signatures, sign the checks. That instruction or the appointment should be clearly communicated to the bank. So the bank's obligation then thereafter is, when a check comes from that company, that you have to see the authorization instructions or the authorization limitations of the company, and see whether the check is duly signed by the authorized signatory or signatories. Right? If you have not observed that, if they have violated their authority, and if the bank has not observed such violation, it is the responsibility of the bank. So therefore, the check is not valid. Then it is called unauthorized check. So then the check is not valid. The bank has to return the money if you have paid the check. That is one thing that you have to remember. Then, if the check is signed in the name of the partnership, each partner is liable under the check. That is with regard to the partners. As you know, partners of the partnership, you are aware, all the partners are liable for the responsibilities or the liabilities of the partnership. Even a single partner has signed that he is signing on behalf of the other partners of the partnership. So therefore, when a check is signed by one partner of a partnership, then all other uh, partners, even though they have not signed the check, they are liable for the amount of the check. So that is with regard to the partnership. So any questions up from here? Signature of the drawer.
Sir, I have few questions.
Yes.
Sir, you said that check can be signed in ink, and can we accept a check signed by red pen, signed by a red ink pen? And
Yes.
in practice, we are not accepting those kind of checks. We are only accepting checks signed in blue or black ink.
Yes. Okay. So that is, I know that there is a practice like that. But when it comes to law, there's no restriction and there's no indication the uh, what color of pen or pencil that you have to use to sign. So then, if we are not accepting a check signed in red color, my advice is the bank has to inform that to the customer before he issue the check. Otherwise, smart customer can challenge the decision of the bank because he knows that it is not restricted under the law. My question, whether you have informed that to the customers, but I have not seen in general business terms and conditions and or in the checkbook that restriction. I don't know your practice. Have you informed that to the customer? Vidura?
No, sir, no.
So
We are
then,
not.
so then if you get a check like that, what do? You return the check. Have you
Yes,
ever come
yeah,
across a
yeah,
situation?
we are not accepting those kind of checks, and some checks are written amounts in words, and the payee is written in blue color pen, and sign date written in black color pen, and those kind of checks also we are not accepting, sir, in practice.
Sorry. I didn't follow you. You are not accepting not only the red color, even it is written in black color. You don't accept.
No, 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 not black colors. Some checks are written in two colors, sir.
Two
Uh,
colors. Okay.
yeah, two colors.
So
Amount in words in blue color, and amount in figures in black color, and
yeah.
date is in another color, and we are
Okay.
not accepting. Yeah,
Yeah. So then, Vidura, on what basis that you are not accepting when you are collecting? On what basis? What is the basis of the rejection?
I think it is a basis is suspect, sir.
Okay.
We are suspecting that
Whether the check has been altered.
altered or check has been not issued by the drawer.
Okay. So others, have you come across a situation like that? A check has been written in two colors, one and a black color and blue color. Rangana, have you come across a situation like that?
No, I haven't, but still, I I think if we have not informed the customer, we may have to collect it. No?
Yeah, Vidura, the law is when you have a reason to suspect, then you should not pay the check without getting a confirmation from the customer. So that what is required. So correct that you can see, you can suspect when you see that check has been written in two colors. the question is still the check is not invalid. You can't say the check is not valid under the law, right? It is valid. Now, for example, we say now when I'm writing, I use a blue color pen. I start writing the check by using a blue color pen, and middle of the check that the ink comes red. Now then I have to use another pen, right? We say I have another black pen and I have used the black pen and I have filled the check, the rest of the check by using a black color. Now the check is in two colors, the filled by two colors. One is blue and the rest of the part is by black color or even a red color. So then, yes, what you said is correct, Vidura. There is a reason to suspect. Now, what is the law? When you have a reason to suspect, the law says the banker should get a confirmation from the drawer. So my next question is, if you reject the collection of the check, what is the narration you put in the check? Vidura, what do you write on the check? You can't say refer to drawer. Or what is the narration you put, Vidura?
Sometimes we don't put narration on the checks.
Sorry?
We do not put narrations on the check.
Don't put a narration.
No, we are not putting that narration.
But that's an interesting.
Yeah, but in practice, it is a practice. It is also an audit query. So when audit comes and they saw a check collected in two inks, they write as a audit query.
Right. Okay. So that's an internal issue that you have. Your audit. Yeah, your audit comes and asks why you have collected the check. So the others on the other side, if you reject to collect the check, the customer can argue from the other side. Customer can say, why you reject the check, but just because that it has been written in two colors. So the law says, however, when there is a reason to suspect, especially with regard to the alteration, the banker, it doesn't say that banker can reject the collection. Two things. One is that you have to put a remarks for the collections, for the clearance. You can say that check has been written in two colors. So that then collect, and especially the paying bank has a duty when there is a reason to suspect for alteration or forgery, that bank has to contact their customer, account holder, and get a confirmation. If the account holder says that the check is genuine, which has not been altered, and he has used the two colors pen, then obviously the check is valid. So the bank has to pay. So anyway, as you said, Vidura, that we have practiced, we have developed several practices, and some of those practices have been accepted by court of law, but this is a new thing that I learned today, this type of practice, because my feeling is that it can be challenged by a smart customer, because there's no reason to reject the collection just because it is written on two colors. But better to discuss with your authorities and see, because I don't see any reason, and I don't see any reason that you can put on the check. And if you don't collect the check, if you return the check, it it is wrong that you return the check without any narration. So that is also that you have to remember. When you are returning the check, you have to give a reason. So unless or otherwise, the customer can claim the bank for wrongful rejection of collection, because it's a duty of the bank under the bank-customer relationship to collect bills of your customer or of your account holder. So that something that we have to think about and we have to discuss further. Thank you, Vidura, for your contribution. That's a new thing that I will search on that further and see what is the practice that we have developed bankers, and how the court will look at that point. Very interesting. If some issue comes before court of law. Any other questions? I have a questions to you. Now, we are talking about the signature of the drawer, account holder. My question is whether one customer can have more than one signatures to operate different accounts. For example, we say I use two signatures. We say one in English and one in Sinhala to operate two accounts. Is it possible? What do you think? So we say now I have two accounts, one account number 1 and account number 2. In the account number 1, in the mandate and the signature card, I have signed I have placed my signature, which is English, which I have signed in English. The second account, in the signature card, I have given a signature which I have signed in Sinhala. So in the same bank, same branch, I'm maintaining two accounts with two signatures. My question is whether it's legally possible, or number 1. Number 2, whether you practically accept that practice.
It is possible, sir.
Possible?
Yeah.
Yes, okay. Ranga, what do you think?
I don't think it is possible, but say if he can have two signatures for his, he can have two signatures. But for banking, he should use only one signature, because bank is not in a position to select the signature time to time for each and every account. So all the banking matters, he should use a single signature, whereas he might have two signatures for some other purposes.
Okay, so you say the practical situation is the customer cannot use more than one signature in the bank for the banking purposes.
Yes.
Okay, right. Thank you. Okay, I will explain the legal situation, the legal principle. A person can use more than one signatures for any purposes. Now, for example, what is the signature? Signature or the specific signature given to the bank is to recognize or identify the instruction of the customer to the bank. Now we say I have one account which I have given English signature, and the second account that I have given single signature. If I issue checks from the first account, that I have to sign in English. So when the check comes to the bank has to verify the signature with the specimen signature given to that account. And the other account, yes, I have to verify. The bank has to verify with my singular signature. Now we have a practical issue. That is the issue that we have. Now you know the one now the signature. Once we give the signature when we are opening an account, we capture the signature and we feed that signature into the system. So that is why that will be considered as the signature of the customer for any purpose of the banking, right? So what happen if we issue a check? When the check comes to the bank, you don't get the physical signature card and tally the signature. You go to the system and you see you compare the signature of the check with the signature in the system, scan signature. So if you have more than one signatures, that will be a problem. One thing. The other thing, I believe your systems, computer systems, will not allow more than one signatures of one customer. So that is another practical problem that we face. Even though the customer is legally entitled to have more than one signatures, that practically it is not possible to have more than one signature of a customer in today's context because of the technology restrictions that we have. So what I want to tell you here is legally it is possible, but practically not possible. There are things that the legally possible and practically not possible, and also there are a lot of things practically possible but legally impossible. So these things that we have to remember. Any other questions?
Hello, sir.
Yes.
Regarding the two signature matter, actually, I don't know the other banks. In our case, the signatures are captured based on the account numbers. Like so, practically, it is possible to have two signatures with two mandates because that is practically possible in the system. In our case.
So Ranga, you are saying it is practically that you can have two signatures in the system.
Yeah, because the customer the signatures are captured for the accounts, no. So
Yeah.
so the teller who is verifying the signature goes by the account number. So if we
So
have
that
to,
okay. So each and every account that you capture the signature separately, or do you have a?
yes, because there are separate mandates for each and every account. So the mandates are captured separately. Say if he has a savings account, there will be a savings account mandate with his signature, whereas another, if he has another current account, there will be a current account mandate with his signature. And in
So
our
then in
case,
that case, Ranga, why can't you allow a customer to have two different signatures? If for example, we say
yeah,
I have a current account,
yeah,
and later on I open another current account,
yeah.
right? So then I feel a signature. I'm sorry, a mandate card. No. So then we say my signature now has changed. For example, that really happened to me. I used to. I am using an account now 20. So 15 years before open account, my signature was very long at that time. So after that, I changed my signature. Now I have a different signature, very short signature in that case.
Yeah.
So can't I have two signatures? The first one that I use long signature, and the second one I use this short signature.
in
Isn't
in in our case, say if a situation like that comes, what we instruct the customer is to request the bank to change his signature to the new one. With that, we'll be changing all the previous ones with the new one, whereas
so
there
then?
will be one signature for the each customer, because I think in practical terms there should be a reason to have two signatures now for a customer. So if it is if unless it is very much justifiable, we don't advise customers to have two signatures because of the practical issues that might arise.
Okay, so that is a practice that you have developed in your
Yeah,
bank.
that's the practice. In legal terms, what you say may is right, but in practical terms, say if the customer comes to subsequent loans or some other things. The signatures, this will get complicated in our documentation. So to
Okay.
have a practical approach, we are requesting customer that.
Right. Because of that, you always insist the customer to have one signature in your bank.
Yes, yes.
Okay. Okay. Got your point. Right. So thank you, Ranga, for your contribution. That's very, very interesting. So, however, yeah, we can develop our own practices, and same time we should know what is the law situation. If someone argue with you, the law says that there's no restrictions to use two or any number of signatures when it for each and every account. However, as we discuss, we have different practices. We have developed different practices. So as long as we have informed the customer our practice, then it won't be a problem. So that is about the signature. Then I'll go to the next one. Then what is a specimen signature? Specimen signature, signature given in the mandate or signature card. So as you are aware, when a customer opens an account, at that point we take a document called mandate, or sometimes we take a separate signature card. Some banks, they use the one document which is called mandate, and there's a part to sign. Sign, that is the signature card. So the signature card, we take the signature, specimen signature of the customer. The signature of the check should be confirmed with the specimen signature. So what we do, we take the signature card or the mandate, and we take the signature of the customer signed in the mandate or the signature card, and we keep that as the specimen signature of the customer. We feed that to the system, and then the check comes to or any other instructions of the customer comes to the bank. We tally the signatures of that document against the signature card signature or the specimen signature in the system, and if for the naked eye, if those signatures are tally, that we consider it is the same signature or the instructions of the customer, and we confirm, then we act according to the instructions of the customer. That is how we understand the instruction of the customer. Then, if not, the bank should refer the checks to the drawer and return the check with the remarks signature differs. So what happened? If the signature differs from the signature card or the specimen signature given to the bank has to return the check with the narration or the with remark signature differs. So that is why we that is the reason that we use the specimen signature to identify the customer's instructions to the bank. So that is about the specimen signature. Then there are another two interesting points that we are going to discuss now. If the customer is illiterate, so that it means he is not capable of writing words or writing letters. There are people, sometimes there are good businessmen. They have not gone to school. They don't know any. They can't write anything. Sometimes I have seen people, they can't even read. Now, of course, our literacy is high. People can at least read and write their names, at least. But there are situations, there can be a person who has not gone to a school or have not learned any word, so therefore they can't write any single word. So then the question is, they can't sign their name. So in a situation like that, the question is whether that person can maintain an account with the bank. So under the contract law, any person over 18 years of age and has a good mental health, so can enter into a contract. So therefore, that person can enter into a contract with the bank and can maintain an account. So he can maintain a current account also. In that sense, he can maintain a current account. The question is, if we maintain a current account and if he is illiterate, he can't sign, how does he operate the account? That is the issue. Then the answer is that person can place his signature by a mark. It is not necessary, as we discussed before, to sign your name. Signature is not your name. You can use a mark, a cross mark or circle or any mark, right? Any person can put a mark, right? Even though he is illiterate, he can put a circle or he can put a cross, anything. But the question is, such a mark or signature easily can be forged, right? So then there's a security problem. So how do you avoid that? The law provides solution for that. It says such signature should be witnessed by two people. So who are the people? Number one, a banker and another witness who is known to the banker. So basically, such person can issue checks, can maintain accounts, can give instructions to the bank. So he can sign by using a mark, a simple mark, a cross mark or right mark or even a circle. That signature has to be witnessed by two people. It's very interesting. The banker has to witness it and another witness who is known to the banker and the account holder. So in other words, the customer then has to come to the bank and has to sign the document in front of the banker and with another witness known to the banker and also known to the customer. Practically, this is not easy. It's not possible actually. You see, it's no point having a current account and a checkbook. And if each and every time when you are issuing a check that you have to witness, you have to take witness to the bank, and the bank and the witness has to sign as witnesses of the check. However, it is possible under the law. That is that what we have to remember, right? Then the next situation, if the customer is too ill to sign the check, this is another practical situation that we can face, right? Where the customer, then sometimes the customers, they all of suddenly get ill, right? For example, we say the customer open a current account, good businessman, he is maintaining the current account for a long period of time, and all of suddenly he got a stroke. Now he is paralyzed. He can't sign. Now what is the situation? Now can he operate the account? The answer is yes, he can operate the account. Now the question is, if we sign, we say his right hand side is paralyzed. Now he can use his, we say, left hand. What happens if he use his left hand and sign his signature? Definitely, it will not tally with the signature in the system, because he's a right-hander. Now he's using left hand. His the other hand, that the signature will not clear like the previous signature which he used to sign in right hand. So then the problem is, then the signature will differ. Then the check, you have to return the check. You can't collect the, or you can't pay the check. So in a situation like this, there is a provision to operate the account. So what is the provision? So the person can sign by a mark again, right? He can put a mark, right? So for example, if he is paralyzed, if he can't use his right hand, he can use his left hand and put a cross mark where he has to sign in the check, draw one signature or circle or whatever. Or still, if he can't use both hands in a situation like that, even we can use his thumbprint, left hand thumbprint on the place where the signature uh, place, right? So again, two witnesses must be witness the signature or the mark. That is important. Here, the different people, different witnesses. One, the customer's doctor, and another witness, not the banker, right? If the customer is too ill, if we can't sign the check, the doctor has to witness it, and another witness known to the account holder. And there is another important thing: the doctor has to give a certificate also, saying that the customer is not in a position to sign the check because of his illness. Basically, this practical problem comes if customer met with an accident or whatever, if it is money in the account, and if he can't take the money because he can't place the signature, and if he want the money, he want to withdraw the money. So we say now we say he has 5 million in his account. Now the family members wants to take him to the Singapore for a surgery, and he wants to withdraw the money. He wants to issue a check and withdraw the money, but or he wants to give instructions to the bank to transfer the money to some other account. But he can't write or he can't sign. So in a situation like that, there is a possibility like this. And if it is not possible, then the person has to go to courts and get an order from the court to transfer, directing the bank to transfer that money to somebody else's account or to withdraw the money or issue the money by closing the account. For that, he has to get a court order. So that is a cumbersome process, an expensive process. You don't want to go to courts. The customer can use this method and transfer or withdraw the money by using this method. So that is about the illiterate customers and ill customers. So any questions from here?
Yes, sir.
Yes.
This is regarding this witness in both these occasions. What in the first it says witness known to the bank. So what do you mean? Like, what is the status of the witness? We should think, take like if it is known to the bank means another customer.
Yeah, okay, right. So the one is now the first one, the banker has to sign. Banker mean any bank officer in the branch has to sign as a first witness, and the other person, another person witness known to the banker. So that means that witness, second witness who is not a banker, that is an outsider, that witness should be known to the banker and as well as to the customer account holder. Otherwise, that he can witness the signature, but he will not identify who is signing. So therefore, so the witness should know the account holder and also should know to the bank. That means that another account holder is the best person to get the signature. When it comes to the banker, there's no requirements to witness by the bank manager. Any bank officer in that manner, in that case, can witness the signature of a illiterate person. Is that clear?
Yes.
So, okay, right. Any other questions? Have you come across a situation like too ill? Second option, second scenario. I have faced several occasions because the bankers, they have not followed the procedure. They were reluctant to follow the second procedure. They insist the bank cannot accept any kind of signature. They insist the customer should go to courts and get an order. Because of that, we went to courts and we got a order from the courts to transfer the money to customer's account, because the customer met with an accident and got paralyzed, and his father wanted that money to treat the son. So then the bank was reluctant to issue or transfer the money to the father's account or to anybody's account without the signature of the account holder. However, even though this procedure is there, I see no banks have followed this, are following this procedure. I don't know whether there's no practice like that. That is the reason. Have you come across a situation like that? Anyone? I don't think no one has a face situation like this. Ranga, Vidura?
Yes, I have faced a situation, but not for a current account. One customer wanted to withdraw funds from his savings account, and he was after a surgery or something. He could not visit the bank, and we sent our officers to their place and got the verification, and some or other made the payment.
So you made the payment.
Yeah.
Did you follow this procedure or some other procedure?
It was because they had these. Did not request for this medical certificate, whereas they had the surgery and diagnostic cards confirming the
Yeah, so
situation.
that you considered as a certificate of the doctor,
Yeah, yeah.
but you didn't get the signature of the doctor witness, no?
Signature, it was not practically possible, so
Yeah,
that
yeah.
we
So
had
that
to go by that.
yeah, I know that. So at least those are the decisions that we have to make. Then when we are doing banking, we have to be practical. Sometimes, even though this law says that that you can get the doctor's signature, it is not possible. Doctors are reluctant to witness, so we have a lot of practical problems. So what we can do, as Ranga said, if there are clear evidence to show that the person has too ill because he has taken a treatment from a doctor or has undergone a surgery. So we see those documents and we then decide whether we go to release the money or not. So sometimes, even though that is there, some banks, they are reluctant to release the money because they think there can be a dispute among the legal heirs or interested parties if we release the money. So therefore, the bank always asks to get a court order. So that is about uh, the signature of an illiterate person and ill person. Then I'll go to the next one. If the drawer's signature is forged, what is the situation? Now, the drawer's signature is forged. What is the legal principle? Right? Now, sometimes, not sometimes, or most of the time, right? If the signature is forged, the person, the culprit, will forge the signature very, very cleverly. In other words, it is not possible to recognize any difference in the signature. Because of that, you recognize or you confirm the signature of the check with the specimen signature. Obviously, if it is visible to the to the naked eye, so that means that the bank has been negligent. If the signature is forged and the signature is different from the specimen signature, still the bank has recognized the signature as the correct signature, then it is clearly negligence. But most of the occasion, it is not the case. Most of the occasion, we say the signature is cleverly forged. Cleverly forged means so clever, the culprit is so clever that he can sign the signature of the drawer so cleverly that you can't see any difference on your naked eye. So that is the most of the occasion that happen. So then what is the legal position? If the signature is forged and if it is so cleverly forged, no difference whether we are covered, the banker. So the principle is this: if the signature is forged, the check is not valid. This you have to remember, and this you have to register in your mind. So very difficult to register this principle in the mind of the bankers. I'm trying to do this for years and years, but I am unsuccessful when it comes to this, because always the bankers say that we are not expert, and we can't see any different. If we can't see any different of the signature for our naked eye, how can we liable? So therefore they don't accept the liability. So it's very difficult. We need to register this principle in the mind of the bankers. However, I'm trying. But you must remember, the law principle is there. You can't change the law. The law says if the signature is forged, check is not valid. Check is not valid. This is a strict liability. The mental part of there's no mental part of this offense. For example, there are offenses, there are wrongs which has a physical part and a mental part. Physical part is the act. The mental part is the knowledge, right? Knowledge or intention. For example, if you know that the speed limitation in the highway is 100, and if you go 120, so that is an offense. That offense, it has a two elements. One is physical element. Physical element is that your action. So you breach the you breach the speed limit. You drive your car over the speed limit. That is your physical action. And the mental part of the action is that you know the speed limitation is 100, and if you breach that, it is an offense. The knowledge is there, right? The knowledge is there. So knowing that you see the speedometer, and you knowing that seeing that speedometer, knowing that you are exceeding the limit, you still do that. We do that, right? So that is a offense which has a mental part or the physical part, right? So two elements are there. However, the signature is forged. When it comes to that, it's a strict liability which has no mental element. Now, for example, when we identify a forged signature, when a banker identifies a forged signature as a signature of the drawer, he has no mental. There's no mental element there, because you don't know, you have no idea about the forgery. If you know, if you have any knowledge, then definitely it is the negligence. There's no way out there. Basically, if you know the signature, if you have any knowledge of a forgery. Forgery means the drawer's signature has signed by somebody else, not by the drawer. If it is not signed by the drawer, it is not an act of the drawer, and it is not uh, not an instruction of the drawer, and the check is not issued by the drawer from his account. If the check is not issued by the drawer himself by his account, then the check is not valid. There's no check, basically. The check is invalid or void from the beginning. So therefore, the bank has no right to debit the customer's account. So if the signature is forged, the bank has no right to debit the drawer's account. So most of occasions that we don't see the difference of the signature, so therefore we pay the check. We pay the check. So once we pay the check, only the drawer get to know about this forged check. So then he basically dispute the payment and he claim the money. So in a situation like that, if the signature is forged, what is the liability? If the check is paid, the drawer has a right to claim the money from the bank. The value of the check he can claim from the bank. So the bank has to return that money to the account holder, to the drawer. If the forgery comes to the knowledge of the drawer, he has duty to inform the bank asset. So then the principle is, if the signature is forged, the bank cannot, the check is invalid. So therefore, bank cannot pay the check. Bank has no right to debit the customer's account or the drawer's account. If bank has paid the check, then the drawer can claim the money and the bank has to return the check, return the value of the check to the customer's account. And if the forgery comes to the knowledge of the drawer, if the customer knows about the forgery, that he has a duty to inform the bank. This is under the Greenwood case. You remember, under the banker-customer relationship, we discussed the Greenwood theory. So, which says the customer has a duty to inform the bank about a forgery at the first instance. So if he has a knowledge and if he has not informed the bank, then the bank's liability comes to it. So otherwise, the bank has to return the money to the customer's account. Then section 24 of the Bills of Exchange Ordinance, or Bills of Exchange Act, it's not Act, actually it is Bills of Exchange Ordinance. Section 24 says, where a signature of a bill, or in that case check, is forged, the bill or the check is wholly inoperative. In other words, it is null and void from the beginning. From the beginning, it is null and void. So that means the bank has no right to debit the customer's account. The bank has to return the money to the customer's account. So there is a case, Bank of Ceylon versus Kolonnawa Urban Council. It was decided in 1951. In there, what happened? One officer of the council has forged the signature of the accountant or the authorized signatory of the council and has taken money from the council account, which was current account maintained at Bank of Ceylon. So over a period of time, this person has forged the signature, and he has forged the signature of the accountant or the authorized signatories so cleverly. So basically, for the naked eye, that any difference cannot be identified, because it was so close to the signature of the drawer or the authorized signatory. So bank has not observed any difference and has paid the checks over a period of time. And at one point, the council recognized that there was a forgery, and the bank has paid number of forged checks, signature forged checks from the account. So then they claimed that money from the bank. Bank didn't pay, return the money. Then the council went to courts and claimed that money. The court was held with the council, and court said, uh, as per the section 24, the bank section 24 does not permit the bank to debit any account if the signature is forged. So the bank said the bank didn't pay the money back. They said the customer, on the other hand, was negligent. Because of that, only the forgery has happened. So that was their argument, which was rejected by the court or court of law. And court said section 24 of the Bills of Exchange Ordinance is very clear. It is a straightforward liability, and it says if the signature of the check is forged, then the bill or the check is invalid. Whether the customer is negligence or whether he has not acted in due diligence, those are immaterial. It is very clear, if the signature is forged, the bank has no right to debit the customer's account. So customer's negligence is immaterial. So this is the principle. Even as of today, section 24 of the Bills of Exchange Ordinance still valid. It's not all amended or altered. So the law principle, even today, is the same. If the signature of the check is forged, check is not valid, wholly inoperative, null and void from the beginning. Bank cannot pay the check. Bank cannot debit the customer's account, has no right to debit the customer's account. If bank has paid the money from the customer's account, customer can claim that money from the bank. Bank has to return that money. So that is the law principle applicable when it is come to the forged signature of a check. So any questions from here? Do you have any questions? Forged signature, are you clear on the forged signature?
Hello, sir.
Right. So no doubt. So now don't say now anything, right? If the signature is forged, is the drawer can prove that his signature has been forged by somebody else. That is the end of the story. No other defense that you can take other than the Greenwood theory and the Macmillan theory. So negligence or any other thing is not applicable. The bank has to return the money to the customer or to the customer's account as per the section 24 of the Bills of Exchange Ordinance. So that this section is very important. It is important for your day-to-day banking practice or the banking work, and also for your exam. Also, if you don't quote the correct sections, that you will be able to get full marks. So therefore, when you are writing your answers, please always quote the correct section of the correct act, and also quote case laws correctly. So then the next one is about the amount of a check. Amount should be mentioned in words and figures. If there is a discrepancy between these two, what is the situation? The bank could seek confirmation of the drawer, or the bank could dishonor the check or reject the check with the endorsement. Amount in words and figures are different, or amount required in words. Now, as you know that there in the check there are two spaces to sign the value of the check. In one place that the drawer has to write that in words, amount in words, and also in figures. So the question is, sometimes you can see different discrepancy between these two. So in a situation like that, the bank has two options. One is you can get a confirmation of the drawer and pay the money, and other one is that you can reject the, or you can dishonor the check, and you can return the check with the endorsement. You have to put the correct endorsement. uh, it is amount in words and figures are different, or you can say amount required in words. So with that narration or with that remarks, that you can return the check. So I have when I asked this question from the bankers, when there's a difference or discrepancy between the amount in words and figure, what practice you apply? In some banks officers, they say that we used to pay the lower value, so that, remember, there's no practice such a practice, because that when it comes to the bills of exchange, there is a practice like that. So because of that, some bankers say that we, in a case like that, we pay the lower value. So thinking that even it is wrong, the payment is wrong, the bank get only a low risk. So therefore, they don't pay the higher value. They pay on the lower value. So for example, we say the customer has written in words as 10,000 rupees, but in figures he has put only 1,000. One zero is missing. So then the bank officers say they pay only 1,000 rupees. So however, that is not a correct practice. That you remember, the practice is this. The practice should be this. There are two options. Either you can get a confirmation and pay, or you return the check. So that those are the practices or accepted practices in court of law with regard to the amount discrepancy in a check. So any questions up to now, or any concerns?
So regarding that forge, signature forge matter,
Yes.
checks. Say, for an example, if a customer genuinely issues the check with his signature and later on claims that it was forged and or something, still the bank is liable to pay the check off.
Okay, so your question is, customer genuinely he has signed the check, the drawer, and the
Yeah.
later he claims that he's not
This
his
was,
signature.
yeah,
Huh?
yeah.
Yes. Okay. Um, the question, if I say yes or no answer, no, customer cannot claim the money, right? So if I elaborate my answer, number one, when the checks comes to the bank, the bank tally the check or compare the check of the signature of the check and the signature in the system, specimen signature, and after being satisfied that the signature is similar, then only you pay. Number one, right? So basically the signature is similar. Then later the account holder says that I never signed the check. So then in that case, it is the duty of the account holder, to prove that the signature is not his signature. So there is a when a dispute comes to with regard to the signature, there are two ways that we can prove whether the signature is genuine or not. So this is very important to the bankers, right? there are two ways. The one way is the number one, prove by witnesses, right? So now you wonder, now have you ever thought why we are taking two signatures, two witnesses in each and every document that we get from the customer? For a loan, for example, loan agreement, overdraft agreements, and even guarantee bonds, we take two signatures of two witnesses. Why? What is the reason? So they are basically witnessing the signature of the person. So what is the responsibility of the witnesses? In case if customer denies the signature, if customer says I never come to the bank and I never sign this document, then the bank, it is the duty of the bank to prove the signature was placed uh, uh, by the customer. So how do we prove? So the customer say he didn't sign, bank say he did sign. Now when we go to courts, how do you prove? We have to prove by calling the witnesses of the document. So they have to come to courts and give evidence and say the customer signed before them. So then they will be subject to cross-examination and all. So therefore, remember, we have to get the signature of the customer before two witnesses of the bank. And sometimes as we know, the practice is sometimes customer comes and sign, then later on two people sign as a witnesses. So the customers normally, or most of the time, don't sign before in front of the witnesses. Witnesses are signed later. So these are the practices that we have. However, the responsibility of the witness is to come and give evidence in court if necessary, when times arise. So that is number one. The method number one, witnesses prove the signature by witnesses. But when it comes to a check, you know that in the check there are no witnesses on the check itself, right? So then how do you prove the signature? Now the second method is by getting expert opinion from the EQD. The person who is known as EQD, examiner in question documents, right? Or disputed document that you can get the government EQD report. So EQD can give an opinion whether the signature has been placed by the customer or somebody else. So there are methods, there are the technologies, there are ways that they can ascertain whether the signature has been placed by the customer himself or somebody else. So those are the two methods that we use to prove the signature. To answer to a question, just because of the customer claim that he has not signed the check, so we don't want to accept the same. The customer then has to prove that in court of law. If he prove the signature is not his signature, that means that the signature is a forged signature. The bank then has to return the money to the customer. So is that clear to you?
Yes, that means say even though the customer has due to his negligence made room for a forgery, still he is not totally responsible for the loss, no?
Ranga, now, as I told you, when the signature is forged, it is a strict liability. As per the section 24 of the Bills of Exchange Ordinance, bank has to return the money. But under the banker-customer relationship, you may remember we discussed two principles under the customer's duty. That is Greenwood theory and also Macmillan theory. So under those two, there are two law principles developed by court of law that can be used as a defense defense in a case like that. So if customer claim money, so if there is a clear negligence which has facilitated for a forgery, then that we can apply Macmillan theory and we can get away from the liability. And the other one, as you remember, the Greenwood matter, if customer's signature is previously forged and he knows that it has been forged before, and if he has not informed the bank, then the second time, if there is a forgery, that we can say that he has not done his the duty from his part, so therefore the bank is not liable. Those are the only the defenses that available to the bank if the signature is forged. However, it is we have to prove our defense, and we can get away if we can prove the defense, or otherwise it is very strict liability or strict point of law under section 24. If the signature is forged, if customer can prove the signature is forged, it's a straight liability. The bank has to return the money. So if we say there is a negligence from the customer side, that means the Macmillan theory or Greenwood theory, if we apply that as a defense, that we have to prove that part, which is very difficult to prove. So yeah, as you said, Rangana, it is a very straightforward liability. Customer's negligence is immaterial if the signature is forged. So that's the answer for that. Any other questions?
So this EQD means this Rasa Parikshana Varta or something?
Exactly, yes. Rasa Parikshana Varta. When we say Rasa Parikshana Varta, it is not only the chemicals they check. They check the signature, handwriting, yes, everything is there. There's a difference between the Rasa Parikshana. Sorry, this EQD means examiner of questions document. Yeah, Sinhaling api kiyane yes Rasa Parikshana, but it's a two different thing. One is for the chemicals that that heroin or whatever, when the police capture those, they give a report confirming the chemicals in there, and that is one. The other one is for the documents, the signature, the letters, handwritings, right? If someone dispute, for example, last will, customer legal heirs dispute that is not a last will signed by or written by the deceased person, then how do you prove? So then we go to the EQD and we get a report from the EQD on handwritings. So if EQD report says the handwriting of the last will is the same handwriting of the deceased person, so then he will compare the documents that the deceased person has written before, and he will give his opinion. So then that is how we prove. That is the answer for that. So any other questions? Okay, then I will go to the next one. Payment on demand. Checks are payable on demand. It is not necessary to include words on demand or at site or on presentation. So this is remember, checks are payment on demand. So when the checks come for the payment, the bank cannot delay the payment for any reason. Right? Can't delay the payment. It is also not necessary to mention on the check pay on demand or pay at site or pay on presentation. But when it comes to a bill of exchange, they can put these words on demand, at site, or presentation, right? Then the check has to be drawn in the currency in which the account was opened. Now, for that, this means if you maintain a rupee account, that you can issue checks only only for rupee values. If you have a current account in foreign currency, you can issue checks only from that currency, foreign currency. You can't issue dollar checks from a rupee account. So that is the meaning of this. The customers are permitted to issue checks on a foreign currency account subject to the foreign exchange laws. The customers are allowed to, if a customer is maintaining a foreign currency account, that they can issue checks from the current foreign currency account. However, there additional law is applicable, that is foreign exchange law also applicable. So therefore, when we are clearing or collecting a foreign currency check, remember, apart from the bills of exchange ordinance, we have to see the laws of foreign exchange laws also. Restrictions are there. There are a lot of things, conversions and all. So we have to be careful. We have to see the foreign exchange laws applicable in a situation like that. So then, order checks and bearer checks. There are two types of checks we can observe. As order checks are checks drawn to a person to the order of a specific person. That is, example, pay Nimal Pereira or order. So the payee's name is mentioned there. So order check is that. Then the bearer check is a check drawn in favor of a person in the possession of the time being, using the word such as pay bearer is known as the bearer check. So when we are writing a check, we can write a check, we can mention the name of the payee in two different ways. So that means that we can mention, the drawer can mention the payee's name by his name, like Nimal Pereira or order. So if you have mentioned the payee's name, so such a check is known as or called as a order check. So other type of check is the payee's name is not mentioned. So you can write a check like this, pay bearer, or sometimes you can we use the word cash. We say cash checks. So those checks are considered known as the bearer checks under the law. So bearer checks, the difference between the bearer check and the order check is, bearer check, any bearer can get the money or the value of the check. It is not necessary to identify the payee, not necessary to mention the payee. So therefore, any person who holds the check is entitled to get the value of the check. But when it comes to an order check, the payee, the named payee, or his endorsee only can take the money or take the value of the check. So that is the difference between a order check and a bearer check. Right. Then the payee of a check can be drawn in favor of one payee or several payees. So this is another important point that we have to remember. When we are naming a payee of a check, we can name the payee by one payee or even several payees. Payee must be named or indicated with a reasonable certainty. Second one, when we are naming the payee, we have to, the drawer has to name the payee, indicate with a reasonable certainty. That means you can write the name of the person. So as I saw you before, you can mention the name as Nimal Pereira. So that is a certain name. So sometimes that the check can be written, the payee's name or payee can be named with a certain way that you can identify the person. For example, that we can issue a check naming the payee as the president of Sinhalese Sport Club. So that or manager of commercial bank likewise. So the person who holds the position for the time being is the payee. Now, for example, today I issue a check naming the payee as the president of Sinhalese Sport Club, right? So then I send the check. So tomorrow the Sinhalese Sport Club, they change the president. Now, who is the payee? Who is capable of getting the money? The person who holds the position for the time being, when the check comes to his hand, he is the person who is entitled to get the money. So the president, it is a post, so that position can take the money. The payee is considered, the payee can be written like that. A check is drawn in favor of a fiction or non-existing person. This is interesting. Can be treated as a bearer check. So now this is the important point that we have to remember under the Bills of Exchange Ordinance, right? If a check is drawn in favor of a fiction or non-existing person, then what is the situation? Payee's name is written, but he is not existing. So in a situation like that, what is the law? Law says that then the check can be considered as a bearer check. It is like a cash check. So therefore, any holder can take the value of the check. So that is about the payee of the checks. So you have any questions? I believe that you have questions from there about the payee. Any questions? Okay. If you don't have any questions about the payee, we will go to the next one, that is about the date of the check. Before that, we'll have a short break, 15-minute break. Now it is 10:35. We'll have a 15-minute break and we'll meet and we'll start from there, date of the check. Okay, we'll start. The next important character of the check is the date of the check. This is another area that we have to discuss a little bit. So check, remember, a check is not invalid by reason that it is not, it is undated. So in other words, if the drawer has not put the date of the check, because of that reason, that we can't say, oh, law doesn't recognize it as a invalid check. So in other words, a check is valid even without a date. But however, remember that we will not collect or we will not pay the check if the if the date of the check is blank. So any holder can put a date of a check if the check is undated. When a check, when you are dating a check, the check can be dated in three manners. That is, number one, you can put the date. The check can be dated on the same day that we write the date check. So that is called dated check. And the second one, the second method is antedated. Antedated means that today I can issue a check by putting a previous date or a date, a past date, basically, right? So I can put yesterday's date and issue the check today. So that type of checks, we are called them as antedated checks. And the third method is the post-dated checks. Post-dated check means that I write a check today, but I put the date of the check as a future date. So that type of checks are called post-dated checks. Now, if a check is dated on a holiday, it should be paid in the following working day. So it's like this. Now, there is a validity period of a check, and the check is dated. We say check is normally valid in Sri Lanka for a period of 6 months. So if checks becomes due on a holiday, and if it is presented and it became for a payment on a holiday, so that date that will not count, and we can pay the check on the following working day. So that you have to remember. If the post-dated check is presented for the payment, this is another important point. If a post-dated check is presented for the payment, post-dated means the check, the date of the check is a future date. The date has not come yet. So the post-dated check presented for the payment before the date, it should be returned with the remarks of post-dated. So the bank's liability or bank's responsibility is to return the check with the narration or with the remark post-dated. Then, if the banker pays the post-dated check before its due date, the banker has to bear any loss that arise out of the transaction. So this is important. If you pay the check, if you pay a post-dated check, the payment is valid. The payment is valid. We can't say that the payment is invalid or payment is wrong. So in other words, the drawer or the account holder cannot claim the value of the check. He can't claim the value of the check because the check is valid, payment is valid, but only responsibility of the bank is, or the main responsibility of the bank or the liability of the bank is, if it is a post-dated check and if any loss occurs as per the payment of such check before the date, the bank has to bear the loss, not the customer. Now there can be a situation like this. Customer issue a post-dated check today, and he put a future date, tomorrow or day after tomorrow date. He puts 2nd or 3rd of February and issue the check on 30th of January. Right? On the next day, following day, that is tomorrow, 31st, right? Customer or rather the holder of the check present the check for the payment. Now it is a post-dated check dated 3rd of February, right? Or we say it is a 4th of February. If it is 4th of February, then it is a holiday. So therefore, it become due on the next working day, right? So 5th of February is the date. Then check is payable. Then we say that the check is presented for the payment on the 31st of January, Monday, tomorrow, and bank by mistake or by after observing the check is post-dated check, paid the check. Bank pay the check. Now what is the situation? Can the account holder dispute the payment? Right? Account holder cannot dispute the payment because the payment is valid. However, there can be a situation like this. If this happened, now tomorrow we pay the check. Day after tomorrow, the account holder stop the payment. Right? He stopped the payment. Now this check has been given to this person, the payee, as a settlement of. Now there is a dispute between the drawer and the payee. Now the drawer immediately stop the payment, countermand the check, because the check is dated 4th of February. On the 1st of February, he stopped the payment. Now what is the situation? Now we are in trouble. We have already paid the check, right? And the account holder has a right to stop the payment till 4th of February because it is a post-dated check. He has exercised his right. He has stopped the payment. By that time, we have paid. So this is a loss to the account holder, the drawer. So then, in that scenario, the bank cannot shift the liability to the account holder. So then we have to bear the bank has to bear the loss because the bank has made the payment for a post-dated check. So that is about the date of the check. Any questions from this dated checks, antedated check, and post-dated check? I believe you have questions. Any questions? No questions. Ranga, are you there?
Yes.
So, Ranga, why the date of the check is important?
Because the customer this comes with the plans of the customer. Because say if a customer wants to make a payment on a particular date, he might issue the check with the plan to pay the check on such date. If we pay it earlier, sometimes check that is meant to be paid on the same day could be returned due to lack of funds or something. If we pay a post-dated check, whereas a correct check might get returned, and there will be a loss to the customer.
Yeah, okay. Rangana, do you think the date of the check is important?
Yes.
Is it important to the bank?
Yes.
Why it is important to the bank?
Because it is part of the instructions of the customer on a check. Like,
yes.
can be
No, now. Okay, right.
He's requesting the bank to make the payment on the date mentioned or after within 6 months after the date of the check.
Exactly. Right. Correct. So now it is the date of the check is important to the bank for two reasons. Number one, we have to decide the date of payment, right? As you are aware, the check is payable on demand. When it is presented, check is payable. Now, if you get a post-dated check, if it is presented before the date of the check, then the bank has a right to return the check. So that is for to identify the check, whether it is a post-dated check, antedated check, or dated check. The date is important. That is number one. And then the number two, as we are aware, the check is valid for a period, for a certain period. In Sri Lanka, the practice is it is 6 months from the date of the check. That is important. From the date mentioned in the check is valid for another 6-month period in Sri Lanka. But in different other countries, they have different time periods when it comes to a check's validity period of the check. However, in Sri Lanka, it is considered as 6 months. After 6 months, it becomes a stale check. So that means that a check is expired, the bank cannot pay the check. Then how do you calculate, or how do you count the 6 months? From what date that you have to count? It is not the date the check issued, it is the date of the check. So if it is a post-dated check, we say the check is dated 1st of March 2022. So that means the check is valid for another 6 months from 1st of March 2022, not from today. So that for that purpose that it is important. So that is the reason the check, even though check is valid without a date, it is important to the banks to have a date, because we have to decide the check, the due date of the check, that is the the payment due date, and the validity period of the check. We have to calculate, or we have to count the validity period on from the date of the check. So that is why the date of a check is important to the bank from bank side. Any other questions from there?
Just a small
Yes.
matter. This was a practical scenario which I faced some time back. There was a check came in with a date 29th of February or 30th February, which was not a date on the calendar.
Yes.
So in that instance, somehow or other we managed to handle that, but I don't know the exact legal situation.
Right. So okay. Remember, were you the collecting bank or the paying bank?
I think it's a
Right.
I think it's a connection.
Yeah. If when you are collecting bank, if you observe the discrepancy of the date, you know that the check, any person can be can insert the correct date of the check if it is a undated check. But but remember, once the date is filled, you can't alter the date. If you alter the date, that whole check becomes an altered check. So as you said, we sometimes we observe these things. We put a 30th February or something like that, or sometimes they put a 31st when you have only 30 days of that particular month. So in a situation like that, what is the what is the the law applicable, and what is the practical way to handle the matter? So those are the things that we have to consider. So the law is very clear: even without a date, check is valid. So just because that the customer has put an incorrect date, that doesn't mean the check then become a illegal or invalid. If it is valid without a date, then a wrong date will not invalidate the check. Then the question is, when we have any doubt or when we have any concern, what we have to do? Then the practical scenario is the bank is covered if you have act without negligence and with due care, then you are covered. So in a situation like that, what you have to do, if you are the paying bank, you have to get a confirmation from the drawer account holder, your customer. You can contact your customer and you get a confirmation from the customer about the date. So if we confirm the date, and if we confirm the payment, then you can put a get a confirmation, and you can put a note on that, and after that you can pay the check. If you are the collecting bank, then when you observe the discrepancy in the date, that it is if you collect the check, then you have to collect the check with the remarks. Then you can inform that in the check, and you can inform the date is wrong. So then the paying bank will be alert to get a confirmation from the drawer before they pay. So that is the practical thing that we can do. Law is clear: even without the date, check is valid. So therefore, just because the date incorrect date is put there, the check we can't say invalid. Anyway, we can't alter the check. That is, we have to remember. Only thing that we can do is we can get a confirmation from the drawer, and thereafter pay the checks. That is what we have to do. So, believe your concern is addressed. Are you clear?
Yes, thank you.
Right. Any other questions with regard to the checks, date of the check? If not, I'll go to the next one. Negotiation of a check. Negotiation of a check means, as you are aware, check is a negotiable instrument. Negotiable instrument means that you can transfer the ownership of the instrument, right? Now, for example, the check can be used to pay a debt, by handing or delivering the check. It's like cash. You can, if you have money, that you can give that money to a seller and you can purchase goods. The checks also like that. The ownership of the check or the title of the check can be negotiated or can be transferred. So it is called a negotiable instrument. Check is negotiated when it is transferred from one person to another person. So there is an error in this slide. It is not to TWO. It has to be TO to another person, right? A holder of a check can be transferred to another person. So because of that, we say it is a instrument. It's a negotiable instrument, and it can be used to pay a debt. So to pay a value. So therefore, it is considered as a negotiable instrument. Section 31 of the Bills of Exchange Ordinance says a check payable to bearer can be negotiated by delivery of the check. Now, when we say negotiability of the check, there are two ways the title of the check can be transferred. Negotiation of a check means passing the title, passing a title from one person to another person. So we know there are two types of checks. That is a bearer check and order checks. Bearer checks and order check. Bearer check means that as we discussed before, any holder can encash the check or get the money of the value of the check. The order check is not like that. Order check, the payee's name is mentioned. Only the payee or his order, his nominee can take the value of the check. So there are two types of checks. So these two types of checks can be negotiated by two ways or two methods. The bearer check. Bearer check means the check, any holder can take the money or the value of the check. Bearer check can be negotiated by delivery of the check. So just if it is for example, if it is a cash check, it is like cash, right? If you have 100 rupee, right? How do you negotiate the 100 rupee? You just give the 100 rupee to the seller. You don't sign it. You don't get the acceptance or nothing. Just give the money, physical 100 rupee note. You give to the seller, and you purchase goods. So transaction complete. Once you deliver the cash note to the other side, ownership transfer with the delivery. The cash checks or the bearer check is similar to that. So once you deliver the check to the other party, the holder deliver the check to the other party, the physical check. So that completes the negotiation. So delivery of check is sufficient, nothing else. So then when it comes to order check, it is different. The negotiation of the order check, there are two parts there. One is endorsement of the holder, and then the delivery, the other part. So there are two parts. As you are aware, if it is an order check, the payee's name is mentioned. If it is just delivered to another party, that new party, the new holder, will not be able to get the value of the check. If it is presented and presented by the holder, the bank will not pay to him because his name is not mentioned in the bill, in the check, on the check as the payee. So therefore, order check, the negotiation of order check, it has two parts. First, endorsement. Endorsement means the payee has to sign his name in the reverse side of the check. Endorsement, remember, endorsement means the payee initially has to sign his name in the reverse side of of the uh, the check, and then thereafter deliver the check to the other party. Please excuse me for a second. Sorry about that. Right. Uh, so negotiation is that when it comes to a order check, as I told you before, it has two parts. That is a endorsement, and then thereafter the negotiation will be completed by delivering the check to the other holder. So, any questions from here? Any questions? Okay, then we'll go to the next one. Holder in due course. Uh, uh, these principles with regard to the holder is important to the bankers because the legal rights of the holder in due course and holder for value is different from other holders. So therefore, the definition and their legal rights uh, we have to remember, because our obligations and the bankers' obligation and bankers' rights are depends on whether the holder is a holder for due course or whether the holder is holder for value or just a holder. So section 29(1) subsection 1 of the Bills of Exchange Ordinance says uh, a person who holds the complete and regular check without notice that it has been previously dishonored, and he negotiated the check for a value in good faith without notice any defect in the title, such a holder is considered as the or named as the holder in due course. This definition that you have to remember, right? Uh, you have to thorough with the definition, right? So what is the definition? A person who holds a complete and uh, regular check, right? Without notice that it has been previously dishonored, and he negotiated the check for a value in good faith without notice of any defect of the title. In a situation like that, holder is considered as a holder in due course. The title of the holder in due course will not affect unless he is a party to any fraud or illegality. So the title of the holder in due course is valid. Now, for example, there can be a situation like this. Drawer issue a check to a party. We say the payee A is the drawer. A issue a check to B. B is the payee. So B negotiate the check to another person C, right? Now C is the holder. C is the holder. Now uh, check thereafter D, a thief, steal the check from C, right? And D D get the check by stealing, and after that D negotiate the check to E. Now E is the holder, right? E takes this check for a value, right? E is the holder. E has no idea that the check has been previously stolen by another party. There's a defect in the title, and E has no involvement, any illegal involvement, or he has no any part. He has not committed any fraud. In a situation like that, E is considered as a holder in due course. Holder in due course, right? So this definition that you have to remember. Then the next one is holder for value. A value for so where a value of a check has any time been given, the holder of such check is considered as a holder for value. Or when the holder of a check has a lien on it arisen from a contract or by implication of contract, such holder is considered as a holder for value. Two ways. One is if the value of the check has been previously paid. That is number one. Then number two, when the holder of a check has a lien on the check arisen from a contract by implication of law, such holder is considered as a holder of due. So these are the two ways that the two definitions for the holder for value and holder in due course. This definition, as I told you, you have to remember, because the legal rights and legal implication of the holder for value and holder of due course are important. Holder in due course are important for us to decide our rights and duties with regard to a check. Right. Then we are going for another important area of a check when it comes to check law of checks. That is about the endorsement. Endorsement. Yeah. Any questions?
So can you please once again explain the holder value?
Holder for value.
Yeah, with the example or something.
Okay, right. Holder for value. Right. Number one, the holder for value. There are two ways a person can become a holder for value. Number one, where the value of a check has been anytime been given, the holder of such check is considered as a holder for value. Now, for example, we say A issue a check to B, right? B negotiate the check, B endorse the check and negotiate the check to C. C presented the check for the payment and check was dishonored, right? Now think a situation like this. A is the drawer, A issue a check to B, B is the payee, B negotiate the check to C. So negotiate means B purchased some goods from C and paid the value of the goods by using the check and negotiated the check, endorsing the check and negotiated the check to C. C is the seller. C present the check for the payment and we say insufficient funds in the accounts A's account, so therefore the check is returned. Now C has the check, return check. Now as per the law, C can file action against two people. That is the B is the endorsee who has endorsed the endorsee who has endorsed the check, and the other party is the drawer who has issued the check. So in a situation like that, B can pay the value of the check to C. Now return check is with C. So B says, okay, don't file action against me. I will pay you cash. So he pay the value of the check and he get the check into his hand. Now the value of the check has been paid. Right? Normally, in the normal scenario, when the check is paid, when the value of the check is paid, check is considered as a discharge. But value of the check has to be paid by the drawer's account, from the drawer's account. Now, what is the situation? It is not the drawer who has paid the money. It is the payee or the endorsee has to paid the money to a third party. Right? Now the check is with the payee, holder is payee. Where the value of the check has any time been given, the holder of such is considered as a holder for value. So holder for value has a right to sue the other parties of the check. So basically that is number one. Number two, when a holder of a check has a lien on it. Now lien on it means, lien we discussed, lien means that you have a right to retain the property of the other person until he settled the total value to him. Now, for example, we say A has issued the check to B, right? It is in the B's name. C has paid money. C has sell some goods to B on credit, and B has not paid the value to C. Now B has given this check to C. C is holding the check on lien until B paid everything to C, right? C is holding the check as a security on a lien. So in a situation like that, the person who is holding the check on a lien is also considered as the holder for value. So that means he get the right of the holder. That means he can sue the parties who have signed the check. So those are the examples that I can give. Are you clear, or do you want a further explanation?
No, sir, thank you.
Right. Okay, so I believe that the holder for value and holder in due course is clear to you. So anyway, that you better read further and understand who is a holder in due course and holder for value, because it is important to the bankers when you are doing banking business, and also it is important to our exam also. So we were then we have to discuss about the endorsement. Endorsement is another important practice or another important law that has been developed. Endorsement means, as I told you before, endorsement is a part of negotiation of a order bill or order check. As I told you, if it is an order check, to complete the negotiation, there are two parts. One, the holder has to endorse the check and then deliver. Endorsement means, or endorsement of a bill or check means, the holder has to sign his name in the reverse side of the check, right? Reverse side of the check. There are three types of endorsement. Those are: number one, the blank endorsement; number two, special endorsement; and number three, restrictive endorsement. So these endorsement are very important, and their features and legal implications are important. The blank endorsement, when you put a blank endorsement means the holder just sign his name without writing any word, nothing, right? The just sign the reverse side of the check. Once you put a blank endorsement, what will happen to the bill or the check? An endorsement which does not specify any endorsee, check becomes payable to bearer. Now, example, We say A issue a check to B. B is the payee. B want to negotiate the bill, right, to a third party. So what he does, he take the bill, he take and sign his name in the in the reverse side of the check. He has not mentioned any endorsee, right? He has not specifically mentioned an endorsee. The name of the endorsee is blank. Just sign the holder's name. He signed his name and give then the check becomes a check becomes a payable to bearer. It becomes a bearer bill. Now what happened? Initially, the check was a order check. A issue a check to B, right? The payee's name is written as BO order. B takes the bill or check and he endorses the check without naming an endorsee. So then what happened? The bill becomes a bearer bill. Initially, it was a order check. Now it has become a bearer bill. Bearer bill means any holder can take the value of the check. So, example for a blank endorsement, just the signature of the holder. That is number one. Number two, special endorsement. Special endorsement means endorsement specify to whom or whose order the check is payable. So in other words, endorsee's name, mention and sign. So when the holder sign, when we sign, we name the C's name in the back side or the reverse side of the check, and after that he signed. So he named the endorsee. So initially the check was a order check, and once you put a special endorsement, then still it is a order check, right? So because you have mentioned the endorsee's name, that is the second type of endorsement. Example, pay Nimal Pereira or order. So you can write these words in the reverse side of the check, then endorse the check by signing the name. So what happened then? The check becomes a order check. Then restrictive endorsement. A check or bill bears an endorsement which prohibit further negotiations or transferability of the ownership. So this is very important part again. Restrictive endorsement means you restrict the negotiability of the bill by putting some conditions. Example, pay Nimal Pereira only. So if you put this word in the reverse side of the bill and or the check, then if you endorse that, then it becomes a restrictive endorsement. That means that we can't negotiate further. Pay Nimal Pereira order for collection. These are the types of words that we can use for restrictive endorsement. By putting a restrictive endorsement, the endorser can restrict the negotiability of the instrument. So these are the three types of endorsement that we can see in the practice and recognize under the law endorsement. So any questions from the endorsement? If you have any questions, okay. If you don't have any questions from there, then I'll go to the next one. Another important aspect of a check. Yes.
So on endorsements, when you say sign your sign your name. It is not the signature actually. Writing the name on behind, like no.
Yeah, that is a good question, right? Uh, the practice is this. Law says the bearer or the payee has to sign his name of the reverse side of the check. So what we do, what we say in the practice is, we ask the customer or to the bearer to write his name in the back, in the reverse side of the check. And further, we take, now we have developed, we take the identity card number also, but it is not mentioned in the law. But however, for the safe side, we ask. Sometimes I have seen the bank officers asked to put the name and also the identity card number. So it is not the signature. It is the name that you have to sign in the backside. It is a requirement. That is the practice in banking. Is that correct?
Yeah, we request them to write the name in a flow, free flowing manner, like.
Yeah. And do you ask them to sign also?
No, just the
No.
name.
Yes. Right.
And another thing, in the special endorsements, if it is only a special endorsement, it can be further negotiated as many times as possible, is it?
Correct. Yes. It is because it is not a restrictive endorsement. So once you put a special endorsement, you name a payee. So the second payee also can endorse, and by putting a blank endorsement or another special endorsement. Likewise, it can be negotiated at any number of times, unless it is restricted by a restrictive endorsement. Clear?
Yes, thank you, sir.
Okay. Any other questions? Okay, then I'll go to the next one, that is about the crossing. Crossings, it's another legal concept developed by banking practices, and also which is in the bills of exchange ordinance also. It's provided provisions for that. So therefore, on the one hand, it is developed by practice of law, practice of banking, and also statutory law. What is crossing? What is the history of the crossing? Crossing on checks were originally originated by the London clearing banks. So originally, only the bankers placed crossing on the checks. So what they did there for the clearing purposes, these banks, they used to uh, uh, use this crossing to recognize the bank's checks. So what they did, when they got a check, they put a crossing on the check and they wrote the name of the bank. Then for the collecting purposes, that they started this practice, and later on it was developed as a principle of banking, or a principle related to checks. So this was in the process of clearing and identify which bank to credit the proceeds. So that is the purpose of starting this crossing practice. Then uh, uh, what do you mean by cross check? There are two kinds of checks. One is open check. The second one is cross check. Open check means the bank is obliged to pay the amount stated in the open check over the counter or through an account. So if it is an open check, that means if it is not a cross check, which is called an open check, it can be honored or it can be paid over the counter. Over the counter without putting to account, or if you or even through an account also can be clear. If it is a cross check, it's different. If it is a cross check, you can't pay over the counter. It cannot be honored over the counter. It has to be cleared through an account. So when you see this different practice, we can see a crossing is an instruction. Crossing is an instructions to the paying bank. So what is the instruction? If it is cross, it means the instruction given to the bank is not to pay the check over the counter. So then if that crossing instruction is given, the paying bank has to pay the check through an account. Otherwise, the payment is illegal or payment is not valid. So that is the meaning of the crossing. So then crossing of the check, the law related to crossing of the check is being mentioned in section 76 of the Bills of Exchange Ordinance. So the crossing is recognized under section 76. So what is crossing? It has defined in this section. Crossing is two parallel transitive lines across the face of the check. So now we as a practice, we know each and every time that when we are crossing or when we take a check cross check, we can observe there are two parallel lines on the across the check face of the check. So what is the requirement? How did practice has come into place? Now we know it is as per the section 67 of the Bills of Exchange Ordinance. So otherwise someone can ask, why can't you put the crossing on the reverse side of the check? Is it necessary to put the crossing or two parallel lines on the face of the check? Or can someone can ask, why two parallel lines? Can't you put one line or can't you put three lines? If it is three lines, whether it is valid crossing. So all these things are now clear. It is very clear. Section 76 says two parallel lines must be there, transitive lines across the face of the check. So it is the face of the check, not the reverse side of the check. So if it is put, if the crossing has been put in the reverse side of the check, it is not considered as a crossing. That is number one that we have to remember. Then the drawer or any holder by crossing a check instruct the collecting bank to collect the check to a bank account. That is number two. So who can cross the check? So when you are looking at this one, you see drawer can cross the check at the time he issue the check, or any holder later can cross the check. If it is an open check, if drawer issue an open check, any holder can later cross the check by drawing two parallel transitive lines on the face of the check. So then it becomes a cross check, right? So who can cross the check? Initially drawer, thereafter any holder can cross. It is not an alteration in that case. So then it is an instructions to the collecting bank to collect the check to a account. That is number one. And the other side, on the other hand, it is an instructions to the paying bank not to pay the check over the counter, and it has to be paid through an account. So that is the instruction. If the bank fails to observe this order, the customer can object to the amount to be debited to his account. This is very important, right? These instructions, if bank fail to observe the instructions, that means if it is a cross check and if the bank has paid the money over the counter, customer can dispute, customer can object for the payment, and customer can claim the money from the bank. So therefore we must be very careful. If it is a cross check, we have to collect the check to account, we have to pay the check through an account, or otherwise the customer can dispute when the bank has to bear the loss in the sense that we have to return the money to the customer account holder and bank has to bear the money, bear the loss, unless the bank can recover the money from the payee. So that is about the introduction of crossing. Any questions from here up to now regarding crossing? Okay, so since you don't have questions, then I'll go to the next one. But remember, the section that you have to remember and the interpretation of crossing that you have to remember for your exam, and also in your future, the banking work or practice that you have to remember. It is better to know what is crossing and what is the law applicable when it comes to crossing. So then we are going to discuss about the types of crossings. What are the types of crossing that we have as per section 67 of the Bills of Exchange Ordinance. So basically there are two types of crossings mentioned in section 76 of the Bills of Exchange Ordinance. That is number one is general crossing. That is two parallel lines across the face of the check with or without words not negotiable. So that is first type. So you just the drawer or any holder of the check can write or can draw two parallel transitive lines on the face of the check. With or without word not negotiable. Sometimes you may see they just put two parallel lines, or sometimes they draw two parallel lines, and in between they write not negotiable. So this creates a general crossing. Just because they have put a word not negotiable, it doesn't restrict the negotiability of the check, unless you have put a restrictive endorsement. The endorsement can restrictive endorsement can restrict the negotiability, but not the crossing. So anyway, general crossing is that two parallel transitive line with or without the word not negotiable. So then the second type of crossing is special crossing. Special crossing is so special because in there, what we do, we write two parallel transitive lines on the face of the check, and in between those two parallel lines, we write a name of a bank, or sometimes name of a bank and also a branch also, right? Two parallel lines across the face of the check with an additional name of the banker with or without words not negotiable. So you can put two parallel lines in between the bank's name and sometimes with the branch name, and if sometimes we put not negotiable words also. So this is a special crossing. Right. So these are the two types of crossings. What is the different? What is the important of a special crossing? Crossing. Special crossing. If it is a special crossing that you may remember, only the bank mentioned in the crossing can collect the check. For example, in this case, in these two parallel transitive lines, they have put the name of the bank, that is a commercial bank. So if they have mentioned this name and of a bank, only commercial bank can collect the check, collect this check. No other bank. So Sampath or HNB bank cannot collect this check to their account. Only commercial bank can. So this check, when you take this special crossing, you can see not only a bank name, their branch name also mentioned. So the commercial bank Nugegoda. So in that case, it is a special remarks. Only the Nugegoda branch of commercial bank can collect the check. Even other branches of commercial bank should not collect this check for their account. So because it is a special crossing, specially cross to the commercial bank Nugegoda branch. So that is the legal principle behind the crossings of crossings, general crossing and special crossing. So any questions there?
So general crossings, if the word not negotiable is not mentioned,
Yes.
can it be endorsed? Or?
Yeah. Yes. As I told you, this word not negotiability on the general crossing has no effect. Basically, it cannot because of the words. It cannot be. It cannot restrict the negotiability of the check, right? By endorsing, by putting a special endorsement or restrictive endorsement in that manner, restrictive endorsement, then only that the negotiability can be restricted. Otherwise, if it is a cross-check, holder can endorse the check, the negotiability is not affected. Only instruction given in this case, the check can be collected through account. It cannot be paid over the counter. That's all.
Whether the non-negotiable words are mentioned or not,
it can be
meaning is the same, no?
It can be endorsed. It can be endorsed and it can be negotiated.
Okay.
Right. Any other questions or any other concerns?
So what about the account pay only crossing? Can it those checks can be negotiated or endorsed?
Yeah, that is another practice that you have developed. Those are actually all crossings cancel, account pay. Account pay only, and the restriction of validity period. Those are not in the bills of exchange ordinance, so it has not been recognized under the law. However, those are some practices that has developed by the bankers. Now, I would like to know what is your practice when it is come to a account pay only crossing? What do you do?
Yeah, only collect the check for the account issued on the check.
Can you repeat it? You collect the check to which account?
To the name written in the on the check only.
Okay, so if it is a cash check,
Yeah.
can you put a crossing and say account pay only?
No, sir. No. No.
It is not possible.
No, it is not. It is not possible. Account pay only check means the name of the account holder has written, and we are only crediting the his account only.
So basically what you are saying is the payee's name is mentioned, and only that you credit the money.
Goes to credit goes to his account only.
That person's account.
Yeah, only.
So
And
basically
it cannot be endorsed. Yeah.
It
No
cannot
endorsement
be
we accept it. Yeah.
Okay. So it restrict the negotiability.
Yeah.
It can't be negotiated first.
Most of the government checks comes with that crossing account pay only and not negotiable.
Okay. Not negotiable, of course, even though the word is there, unless it is restricted by an endorsement, it has no meaning or it has no effect. But as you said, if you have developed a practice, account payee crossing, that is one thing that you have developed, which is in the practice, but it not mentioned in the in law. So what you said is, if that crossing is there, the transferability or the negotiability comes to end, you collect only to that account. That's what you say, right? Okay. So then I have another question. What is about this? All crossings are cancelled. Sometimes you have that practice also, no?
Yes, sir. When we got a check with crossing, cash check with a cross, and that should be deposited to the account now, sir.
Yes.
And if customer wants to get the cash from the counter, we put that statement all crossings cancelled and get his or her signature, account holder signature.
Okay, so basically what you do is the cross check. The cross check means that you can't pay over the counter, so you put a endorsement or a note on the check saying that all crossings cancel, and get the signature of the holder, and you pay over the counter.
Yes, we are paid.
So okay, so those are practices actually developed by bankers. I don't know. The law is not clear when it comes to those practices, because those are not challenged in court of law, and there are no decided cases on those matters. Because now, for example, as you said, when you the crossing is a clear instructions to the bank to collect the check to a account. But when you put all crossings are cancelled, that means that you cancel the instructions given by the previous holders to the bank, and you pay the check over the counter. So if
Yes, sir. We are considering that that check is a cash check.
Cash check or bearer check, right?
Bearer check, yes.
Yes. So if someone challenge, I don't know, in future, if someone challenge, it was a cross check, and bank has no right to cancel the crossing, kind of thing, that will be tested in court of law, and then only we can think, or we can decide what is the law. Actually, those two practices, I know that practices are there. Everyone knows those practices are there, but they are not really tested in court of law. We'll see in future, right? Sometimes I can, most of the time, not sometimes, most of the time, the court will accept those practices, because the law, as I told you, has been developed by accepting the practices of the bankers. Right. So that is about the crossing. Any other?
And sir, this regarding when crossings are cancelled, what the correct procedure is to pay the check only to the customer. Not a third party can come and cash the check if the crossings are cancelled.
What do you mean by the customer? Customer is
The grower.
The payee, drover.
Yeah.
Not the drover. It can't be drover, no. The drover is the person who has issued the check, no.
Yeah. If the check is issued with the crossing, and subsequently the crossing, if the crossing is cancelled, still the drawer has to sign for that, no?
Right.
So in that case, if a check comes with a crossing cancellation, which was signed by the drawer, we normally pay cash over the counter only to the drawer, not to a third party.
Okay, right. So the account holder can take the money from his account.
Yes, by cancelling the crossing.
Right.
That's
Not a third party. Holder cannot take, but only the drawer can take.
Only the drawer can. Yes.
Okay. So in that case, of course, then you are safe, because he takes money from his account. But if you pay a third party, then a drawer can challenge later. But yes, I see these practices, different practices. But as I told you before, these are not really tested in court of law. So once it is tested in court of law only, we can see how the court will or how the court will recognize these practices. Sometimes or not, sometimes most of the time the court will accept these practices. Then it will become a part of the banking law. So anyway, these are practices that we have developed at the moment. So any other questions? Shall I go to the next one then? Okay, so then we'll continue. Even if the check is not crossed by the drawer, any subsequent holder can cross the check generally or specially. That is as per section 77. Initially, the drawer can cross the check. If he has not crossed the check, any subsequent holder can cross the check. Any holder can cross the check generally or specially. If the check is crossed specially to more than one bank, the collecting bank can refuse the payment, or collecting bank can refuse the collection of the check. So, for example, if it is a special crossing, and in the middle of the two parallel lines, if you have written more than one bank, now for example, there's a special crossing in between two parallel lines that it has been mentioned banks name as Sampath Bank, Commercial Bank, and HNB. Now three banks mentioned. So then the instruction is not clear. There is ambiguity. So therefore, in a situation like that, if it is presented to the Sampath Bank can refuse to collect the check because it is the crossing is not clear because it has been specially crossed to more than one bank. That is as per section 79 subsection 1 of the Bills of Exchange Ordinance. And if the bank pays the check contrary to the specific crossing, the bank is liable to pay any loss or damages to the true owner. I have underlined the word true owner. That is another important concept under the banking, under the check law that we are going to discuss later. Who is the true owner and what is his rights and all. So for the time being, that remember, if a check is crossed specially to a bank and another bank pays the check without observing the crossing, special crossing, the payment is valid, but still valid. But as I told you before, if there is any loss or damage to the true owner, not to the drawer, right, not to the account holder, to the true owner, then the paying bank is liable for that. That as per the section 79 subsection 2 of the Bills of Exchange Ordinance. So this is about the crossings, right? Then
Sir,
yes,
sir, I have a question. And
yes.
sometimes, the RDB bank, they maintain accounts with us, and they deposit checks to their account maintained with our branch. And sometimes we got the checks with their collection. They collect the checks and they deposit to our account to clear. And they in the backside of a check, they put අයනීය තහවුරු කරන ලදී. The
What is it? මොකද්ද තියෙන්නේ?
අයනීය තහවුරු කරන ලදී. And the check is drawn not for the RDB bank.
Okay.
Check is crossed. Check is crossed.
Check is crossed, and what is the back in the reverse side? Then what
Reverse side, they put the seal අයනීය තහවුරු කරන ලදී.
අයනීයදිය.
අයනීය තහවුරු කරන ලදී. All the credits are verified.
All
and
the credits
they
are
guarantee,
verified.
yes, they guaranteed the check.
Okay.
And what about that's we don't know about the legal aspect of that.
Of course, I'm also not very clear on that practice. As I told you, this is the first time actually I heard this one. I have not come across a situation like this. I mean, a practice like this. But I will check and let you know. Can you again explain what is the practice? You have an account of which bank?
Uh, Regional Development Bank.
A regional
Regional
development
Development.
bank. Oh, okay.
Yes, they are collecting checks on behalf of their customers.
Right. Okay, but they can't maintain current accounts, no?
Yeah. They can't maintain current accounts, but they
Right.
maintain a current account in the name of RDB Bank in our branches.
Okay. Well, so your customer is regional development bank.
Regional Development Bank.
They are
Yes, they
maintaining
collect
a current account. They are
current
maintaining
account.
current account, right?
Yes,
And
and they collect checks on behalf of their customers to their accounts.
so
And
basically, what they do is their customers receiving checks from other banks'
yes,
customers.
yes,
Those checks are collected by RDB Bank,
and
and
they
they
deposit
deposit those money as a checks to
checks
the
to the account maintained in our branches.
right. So those checks are basically endorsed to
Uh,
RDB.
yes, those checks. Most of the checks are not endorsed for the RDB or their customer.
So then, what is the process then? How the RDB get the money for the checks?
Actually, sir, and here's the case, sir. And I got a check. Mm,
Say you are a customer of RDB,
yes,
right? And
and check is
you got
yeah, the government check has been issued in the name of, as an example, Nimal Pereira,
right,
uh, account of then some account number is stated on the check.
right, okay,
Then that uh, Nimal Pereira has account in RDB Bank, and he deposit to the uh, that check to the RDB Bank account. Then RDB Bank comes to us uh, to deposit those collected checks to uh, their current account maintained in our branch,
yes.
and
Now
they put
RDB has to pay the value of the check to
check.
Nimal Parwana.
Yes, they have to pay the value of the check to
Yes.
their
So then
customers.
RDB has to get the money from the relevant government authority.
Yes, and
So
they have to clear the checks, and
so
they don't
how,
have the
how
system to clear the checks.
so how they clear the check? That is my concern. So now it is a third party check.
Yeah,
It
it
is
is a third party check.
yeah, and it is not endorsed to RDB,
Yeah,
and it is deposited to RDB account. And how do they get the money, the value of the check?
yeah, that's why they put the all the credits are verified. The අයනීතිය තහවුරු කර ගැනීමේ seal.
So
Yep,
then
back in the back side of the check.
right. So then what is the clearing process? Do you send the checks to
Yeah, we are just sending checks to the clearing house,
right?
uh, and we collect those checks to the RDB current account,
So the basically money comes to the current account of the
and
RDB. Then
RDB
RDB
transfers to the money to the
relevant.
relevant accounts.
Okay, okay. So actually, this is the first time that I heard about this practice. Uh, Thank you raising this concern or bring this concern. It's a new thing to me. I would like to study about this and uh, uh, give you an answer. Actually, I'm not sure about the practice because this is some strange practice which is not very clear. I would actually I want to study further.
Yes, sir. RDB Bank, NSB, all the banks are practicing these practice.
No, I can understand if they endorse the check into their name and deposit to their account and get the money, but
Yeah.
without endorsement, my question,
Yes, they guarantee, sir. They put the guarantee to credit those their account holders' accounts.
right. So you have a separate agreement with the RDB
No, sir.
for
No,
that.
no, no, no,
You don't have. You don't have.
no, no. We don't have. We are just rely on that seal.
So basically, that you are allowed them to maintain a current account. They bring third-party checks and deposit there, and
Yeah,
you support them to you provide the service to clear those checks
yeah. We
through
are clearing.
clearing,
Yeah.
and then thereafter they distribute the money to their customers.
To their customers. There is a process,
Right.
and we only
You
just
are,
rely on the that seal.
yeah, but in that transaction you don't get any liability, no. So
No, no, no. We are not liable. We are not
you are
liable.
not liable. You are just
Yeah.
you are just
We are just
providing
providing the
service.
clearing service.
Okay, okay, right. So thank you. I will study further on this matter, and I will try to give you a clearance or comment on this next day. Right. Thank you. Any other questions? Any other concerns? That's thank you very much. That's why I said that it's discussion is very important because I learned a lot today from you because you are in the practice. New things always comes with the practice. We have developed a lot of practices. Thank you very much. Thank you again. Okay. Any questions from here? Or if not, we'll go to the next one. That is regarding the collecting bank with regard to checks. Collecting of a check, a collecting bank is the bank who undertakes to collect the amount of checks and bills for its customers. The bank has no legal obligation to collect checks drawn on other banks. This is another important point that we have to remember. When, as I told you before, when we are doing banking businesses, when we allow the customers to maintain current accounts, we have a dual character. We have dual role to play. That is one side as the collecting bank and the other side that we are acting as the paying bank. Bank collecting bank means the bank who undertakes to collect the checks for their customers. That is an obligation under the banker-customer relationships. Once we allow the customer to open a current account, we are obliged to collect the checks. We are obliged to collect the checks, so we are bound to collect the checks issued by our own bank. Now, customer issued the checks from his own account, or if he received checks from our customers issued by our bank's accounts, then we are obliged to collect those checks to our customers' account. However, we are not bound to collect the checks of our customer issued by other banks' accounts. Now, for example, if we say if we take a HNB, HNB has a customer, a current account holder. So between the HNB and the customer, there is an agreement or there is a contract, that is banker customer relationship contract. Under that, HNB is duty bound to collect the checks of their customer if those checks are issued from HNB accounts. Now, for example, we say the customer is Siripala. Siripala is maintaining an account with HNB. Siripala gets checks from other customers. We say there are other customers who are also HNB customers who gives checks to Siripala. So then if Siripala brings HNB checks, third party HNB checks that he received from others, and if we deposit that checks to HNB account, HNB can't refuse. HNB has an obligation to accept or to collect those checks. But Siripala gets not only HNB accounts checks, but he will get the checks from other persons who are other customers of other banks. Sampath banks, commercial bank customers also give checks to Siripala. Now Siripala brings those checks to HNB to deposit his account at HNB. In a situation like that, the bank HNB does not have an obligation to collect those checks. So remember, the bank has an obligation to collect the checks if those checks are checks of the same bank. Otherwise, there's no obligation. However, what is the practice today? So we don't restrict our customers. We don't say that you can deposit only the checks issued from our bank accounts. It is not like that. We allowed our customer to deposit any check that he received from any bank. So therefore, even though it is not an obligation, that is an extra service that we provide for our customers. So, however, it is an extra service performed by every bank today. Every bank that we provide this service. Otherwise, we can't stay in the bank practice or banking business unless we give these special services to our customers. So the collecting bank has to take extra precautions to safeguard the interest of the true owner if you collect other party or other banks checks. Again, I have written here, it is the interest of the true owner. It is not the interest of the customer. It is not the interest of the drawer. It is not the interest of the payee. It is the interest of the true owner. This word true owner, it appears everywhere in the bills of exchange ordinance with regard to the checks and also with regard to the bills. So therefore, if you are collecting checks of other banks, you have an obligation to safeguard the interests of the true owner. When it comes to true owner could be your customer, or it could be completely a third party who is not a customer of the bank. Now, for example, take this scenario. Account holder, HNB account holder is Siripala. Siripala issue a check to Gunapala, right? Gunapala is the payee, right? From Gunapala, we say Dadapala steal the check, stolen the check, right? Now the title of the check has not been passed from to Dhanapala, because Dhanapala steal the check, right? Dhanapala negotiate the check, we say, to Nimal, right? Nimal is the owner now. Nimal is the holder of the check. Nimal, we say Nimal negotiate the check for a value, and Nimal hold the check now. Now, who is the actual or the true owner of the check? If I say this transaction again, Siripala is the account holder, issued the check to another person, right? We say, what is the name I mentioned? Right? Gunapala, right? Siripala issued the check to Gunapala. Gunapala is the payee, right? From Gunapala, Dhanapala steal the check, right? Then Dhanapala negotiated the check to Nimal, right? Now, who is the true owner? Whether it's Siripala, whether it is Gunapala, whether it is Dhanapala, or whether it is Siripala. Can someone answer to me and say who is the true owner of the check? Ranga, can you
The first person over Gunapala.
you say it's Gunapala.
Yes.
What about Nimal? Nimal doesn't know anything about the previous defect of the title, and he doesn't know, he is not involved in any fraud or anything. What do you think? Is it Nimal or Gunapala?
Well, I think he's the holder in due course.
Okay. And true owner
is Gunapala.
Gunapala, you say.
Yes.
Right. Very good. Your answer is correct, Rangana. The true owner is not Nimal. As you said, Nimal is holder in due course. Gunapala is the true owner. Right? Gunapala is the true owner. Now see this transaction. Siripala is a customer of HNB. Right? And he issued the check to Gunapala. We say Gunapala is a customer of Sampath Bank. From him, check is stolen by Dhanapala. We say Dhanapala is a customer of Commercial Bank. Right? Then after that, Dhanapala negotiated the check to Nimal. We say Nimal is a customer of Bank of Ceylon, right? And thereafter, Nimal deposited the check to the Bank of Ceylon, right? And cleared the check and got the money. Now, who has taken the money? The money has gone to Nimal. Nimal is not the true owner. Nimal is the holder for value, or holder in due course rather. Holder in due course. Money should go to the true owner. Money, the value of the bill or the check should go to the true owner, not to anybody else. Now, in this scenario, if you take this scenario, actually the value of the check has not gone to the true owner. Gunapala has not got the value of the check. The value of the check has gone to Nimal, to a wrong party. Right? In this case, what is the scenario? What is the obligation? The collecting bank has to take extra precautions to safeguard the interest of the true owner. So that is why I say, when we are dealing as a collecting bank or when we are dealing as the paying bank, we have an obligation towards the true owner, not to our own customer. Remember, our interest or our obligation to safeguard the interest of the true owner. True owner could be a third party who is not known to us. Now, in this case, in this scenario, the paying bank is HNB, because their customer Siripala has issued the check. So check has been paid by HNB. Check has been collected by BOC. Nimal is a customer of BOC. True owner, that is Gunapala, is a customer of Sampath Bank, not known to HNB, not known to BOC. But BOC and the HNB both, that is the collecting bank and the paying bank, has a duty towards the true owner. So that is why I say it is dangerous, and also we have to take all precautions as a collecting bank and also as a paying bank to safeguard the interest of the true owner. Always keep that in your mind. It is not sufficient to safeguard your own customer, you have a duty towards another person, that is the true owner when it comes to check transaction. So therefore, you have an obligation to take precaution to safeguard your own customer, and you have to safeguard your interest of your bank, and you have to safeguard the interest of the true owner, who is a third party who is not known to you. So that always remember that in your mind when you are dealing with checks. Okay, so next that we are going to discuss about the risk and liability of the collecting bank. Under that, we are going to discuss about the breach of contract and conversion. So it's now 12, almost 12:30. So there's no sufficient time to cover these two topics. So therefore, we'll stop at this point. Next week, we'll discuss about the risk and liability of the collecting bank. So thank you very much for the participation today. We'll meet next week from here onwards. Thank you very much.